Good afternoon, everyone. I am Becky Young. I'm a partner at Grossman, Young & Hammond in Washington, D.C., and I'm here today with my colleague David Morris. We're going to talk about E2 and EB5 investor visas and investor green cards. So to introduce myself, I have been working in the field of immigration for over 20 years. I think it might actually be close to 30 years at this point. I work with clients in all industries and with really all types of business visas. And E2 non-immigrant investor visas are definitely one of the focus areas of our practice. And I am joined today by David Morris, who focuses specifically on investor visas. David, would you like to briefly introduce yourself and explain your experience with EB5?
Sure, that sounds great. Thank you, Becky. So I've been a practicing immigration lawyer since 1992, and probably for the last 20 years have been working with foreign investors, both E's, but more often EB5 immigrant investors. I am the chair of AILA, American Immigration Lawyers Association National EB5 Investor Committee, and I've had that role for the last 4 years. I'm the editor of AILA's textbook on the investor visa program. And in addition to all that, I also am the co-owner of the DC Regional Center. That's an entity authorized by immigration to do EB5 projects. And I've raised about $400 million from 800 investors to do EB5 projects, mostly in the DC area.
Awesome. Thank you, David. And we are going to talk today about start with E2 visas, which are the non-immigrant or temporary category for immigrant investors. So we'll go through some background information about the E2 category. Even though it is a temporary category, it actually can be extended indefinitely. So it can be a longer term option, but it's not a permanent option. So we'll talk about the E2 category, what countries you can be from to qualify, what's the minimum investment. We'll touch a little bit on how to make an E2 business plan. It's kind of a unique type of business plan that might be different from what you've seen before. We'll talk about how to prepare for your in-person visa interview at the consulate, and then very briefly touch on the tax benefits of E2 status. I'll say it here and I'll say it again when we get there. We are not tax experts. We always refer out to tax experts when there are tax questions, but we wanted to just share sort of the very basic parameters of taxation for E2s. Then we will talk about the EB5 program, again, just sort of talking about the structure, the process, and the timeline. There have been a lot of changes to EB5 in recent years, more so than E2. So David will be able to give you really the latest and greatest about EB5. He'll talk about source of funds, which is always an important issue for EB5. And then we'll save some time at the end for questions. So let's get started with the basics of the E2 visa. So there are 9 requirements for the E2 investor visa. The first is that there is a treaty between the US and the investor's home country. The second is that the investor or the business possesses that nationality of the treaty country. So for example, if you are Argentine, there has to be a treaty between Argentina and the US, which luckily there is. The third point is that the person applying either already has invested or is actively in the process of investing. The fourth is that the enterprise is real and operating. Fifth, that the investment is substantial, and we'll talk a lot more about that. Next, that the investment is more than a marginal one. The next one is that the person who is coming as the main applicant is coming to develop and direct the enterprise. The next requirement is that if the person is not the investor, but rather an employee, that they're coming to fill an executive or supervisory position, or that they have essential skills. And then finally, that the applicant intends to depart the US when E2 status terminates. So let's dig into those in a little bit more detail. the first point is that the requisite treaty exists. So you can follow this link, and we will share these slides after our call today. You can see a list of the countries with which the US currently has investment treaties. And the newest ones, I think, are probably Israel. I know that there are some other treaties that are under negotiation. So this list does get updated, not frequently, but from time to time. And sometimes treaty countries fall off. So I can't recall which country, but there's one country that actually is grandfathered. So if you didn't already get an E2 visa from that country, you can't get a new one, but they still are renewing existing treaties. So this is the very first and most important step if you want an E2 visa, is to make sure that the country of nationality is on this list. Notably, none of the BRICS, so Brazil, Russia, India, and China, are on this list. And so when we get to EB5, that will be an important point because, as you can imagine, there are a lot of investors from those countries, and so they are closed out of the E2 visa, and so sometimes the EB5 might be the only investment option for them. The next is that the individual or the business possesses the nationality of the treaty country. So that's usually a pretty straightforward finding. If it's an individual investor, you look at the passport to see the nationality of the individual investor, and you would have to submit the passport identity page to prove the individual investor's nationality. If the US business is owned by a company, you look to the individual owners of that company. And so if it's a company with private owners, you would have to submit the passports of those individual private owners to show that at least 50% of the US company is owned by people holding the passport or holding the nationality of that particular treaty country. If the owner of the US company is a publicly traded company, then there's a presumption that the US company shares the nationality of that publicly traded company. The publicly traded company is defaulted to the nationality of the country where it's publicly traded, and the US company would also be assigned that nationality. The next one is that the applicant has invested or is actively in the process of investing. And this is one that comes up a lot in our practice. The scary thing, I guess, about the E2 sometimes is that there is a lot of risk, and that is a requirement that the funds have to be at risk. So a speculative enterprise or one that really hasn't started business is not going to be ready for an E2. We've had cases where someone went to the embassy to apply for an E2 visa, and the embassy said, wow, this looks like a great business, and we would approve an E2 visa, but not yet because you haven't really started doing business and you're not close enough to the start of business. So we're going to give you a B1 business visitor visa, and we'll annotate that visa to indicate that you're a prospective investor, and you can come to the US to sign a lease, to sign vendor contracts, to hire employees, but we're not actually going to give you an E2 visa until you've done those things. So we really want to see that the company is either already actively in business, which can be hard if you are the primary investor and you're planning to get the company started. How do you get it started when you're not in the US? Or that the company is really ready to launch, like within, a few weeks or maybe a month of the primary investor arriving in the United States. So you want to show that the lease is in place or, very close to being finalized, that you do have vendor contracts, that you have expended money for marketing. That's usually one of the sort of first upfront expenses that any company has. So you can show the types of preliminary expenditures that you have, but they should be more than just sort of exploratory. They really need to show, your expenditures really need to show that you're actually going to start the business once you arrive in the US. You can place the funds in escrow, and we have done that on occasion. In my experience, sometimes that does cause the consulate to question whether you are close to the start of doing business, but it's absolutely under the law. It's a legitimate way to, to transact your E2 and to show that there's a condition in the escrow account that the funds will be released upon issuance of the visa.
Yeah, so Becki, on that one, let me just say, so in the escrow, if there's a third-party escrow agent and there are no way out of the escrow other than irrevocably committing the funds to the project or release upon approval of the E. So if the E visa is approved, that gets presented to the escrow agent who then releases the funds. And that makes the consular officer feel like, okay, we're not going to approve this, and you're going to take the funds and do something else. Or if the E is denied, then you present that to the escrow agent who then says, okay, you didn't get it, so we're going to put the funds back. And it does make people who are not so much starting their own business, right? Because they can put funds into their own new startup enterprise. And if they don't get the e-visa for whatever reason, they can take it back out because they can control it. But if they're buying an existing business, let's say, so a couple $100,000 to buy an existing business, they're saying, I only want to buy this business if I get my E. And so the escrow mechanism is a way of showing the consular officer this is not too speculative.
And that's a really interesting point, David. I would say that probably I've handled more cases where the investor was actually the business owner, but I have definitely encountered the issue where someone is purchasing an existing business. And I think that it can make it really, it's a challenging term to negotiate in a contract of sale, because often the seller doesn't want to, make the sale contingent on issuance of the visa. So I'm curious to know what real life experience you've had with that type of escrow agreement and whether it caused your clients any challenges in negotiating the sale of the business.
Yeah, so that's a really good point. I think it has to do with the economy, frankly. Think about it like real estate, right? If someone has a piece of property that's been on the market for a while, if someone finally comes around and says, listen, I'll buy this, but I want to get my visa first, so we're going to put it in escrow. That person may be so desperate from waiting on that listing, like, okay, fine. It hasn't been snatched up by buyers, so this sounds like it might work. Whereas if it's like a really hot property, they'd say, I'm never going to tie this up for 2 months or 3 months to see if you get your visa. In the meantime, lose these prospective purchasers. So I think part of it has to do with, the seller of the business needs to have some reasonable expectations. And, if it's a hot business, he doesn't have to wait, or she doesn't have to wait. If it's a slow business and it ain't moving, well, maybe this is the way to do it, and we'll work with you.
Yeah, that makes a lot of sense. The next provision that we want to talk about is that the enterprise is real and operating. So a lot of inquiries that we get about E2 are about passive investments. And David will talk about active versus passive investments in the context of the EB5. But the thing to understand about E2 is that it can't be a passive investment. It has to be a company that's really operating and doing business. And so a lot of people want to invest in real estate. Can I buy a house? Can I buy a commercial building? And the answer is generally no, unless you can show that that's an enterprise that will employ people, employ US workers, and that will, keep you busy. So a passive investment generally doesn't qualify for these purposes. I saw someone chatting the other day about whether an Airbnb could qualify as an E2 enterprise. And I thought that was a really interesting question. I know that that's a very popular business to run these days. I actually operate an Airbnb myself, and I can tell you it is not a full-time job. If it were, I would not be doing it. I think if you had, in my opinion, a single Airbnb would not be a good E2 investment. But I think if you had a portfolio of multiple Airbnb properties where you employed maintenance people, where you employed maybe a local manager, where you employed cleaning people, so to show that, it's more than just sort of a single passive investment, then you might be able to succeed. But the business does have to be real and operating. Substantiality is a really important question and one that we get asked a lot. And there's nothing in the statute or regulations that defines how much money is substantial. And there's not a lot of really authoritative guidance on this point. So you will hear anywhere from 100,000 on up. I think, most immigration attorneys in my experience will recommend an investment of at least 100,000. Our firm generally likes to see an investment of 200,000. That's only because we have seen cases with less than that were actually denied for substantiality. So I think that a lot of consular posts would be fine with an investment of 100,000, but I personally, as a lawyer, feel more comfortable with a $200,000 threshold, just because I think that's the level at which most consulates are not going to question the investment. I've definitely heard anecdotally of cases with an investment of less than 100,000 being approved, but I think that is a really risky case, and you would have to be prepared for the possibility that it might not be approved based on substantiality. David, I think I saw somewhere that you recommended an investment of 150,000, and I was just curious to know about your experience with substantiality in the E2 context.
Yeah, so I agree with you. There is, unlike the EB-5 that we'll talk about later, where the government sets an exact minimum dollar amount, it must be a greater than this number. The E2 doesn't have that. It just has the word substantial, and it leaves us all guessing. And so, like everything, some people will try to be as risky as possible and push that down and test the limit of, can we get away with 75,000? Right. But I think that in my mind, 150 is a good place to start. And I think what the consulates do as they review this, I think they look at the type of business and they say, how much money do you really need to get this business going and to operating it? And so if it is a business where, let's suppose you're going to have an engineering consulting firm, so it's going to be you and three junior engineers and some computers and some kind of minor technical office equipment, right? Okay, so maybe you only need $150,000 to get that going. But if you're going to create a restaurant, right, just having the infrastructure for that restaurant is going to require a whole lot more money to get that off the ground. So I think the consulate's going to try and tie those two together to say, there's no minimum dollar amount, but we need to see that you have enough to make this thing viable. And so we're going to use that as the substantial test. That's kind of the way I always think about it.
Yeah, I think that's absolutely right. The next requirement for the E2 is that the investment is more than a marginal one. And so this sort of ties back to what we were just talking about. And it also relates to the issue of job creation for US workers. So before the Trump administration, job creation for US workers was not such an important focus for E2 cases. I mean, it always played into consular decisions, but during the Trump administration, it was explicitly added to the FAM, the Foreign Affairs Manual, which is the manual that State Department adjudicators use to process E2 visas. And so it really has entered the consideration for visas. And so we'll talk about business plans in a minute, but when we do a business plan, we want to see a staffing plan. We really do want to see that the business is going to hire US workers. So a business that just is going to employ the primary investor for the next 5 years is probably not a great E2 investment or a great vehicle for an E2 visa. If you can show that, in year one, it's just going to be the primary investor, but then in the next year, you'll hire a US worker. And then in year 3, you'll hire 3 more US workers. That's what the consulate would like to see. So a business that has a plan for growth and a plan for providing employment to US workers. So not only are you providing a living to yourself, but you're also providing a living to US workers. We do sometimes also try to address this marginality by showing independent resources for the E2 investor. So if the E2 investor is independently wealthy and they don't need to depend on this business to earn their living, And we have a lot of E2 investors who don't even take a salary from their business. So that's part of the argument that we make, is that they don't, they're not using this business solely to support themselves and their family. But definitely US workers are an important part of that. Then we have two types of E2 applicants. So we have the primary investor, who's the person whose own funds would be invested in the business. And then the next point will be about employees. But let's talk about the individual investor. So that person, if they are coming to the US, they have to be coming to the US to develop and direct the enterprise. So this goes back to the passive investment idea. Sometimes we'll have someone who wants to get an E2 visa and then they want to bring their family members, and their family members can get a work authorization, an unrestricted work authorization, if the primary investor has an E2. So sometimes somebody will say, well, I want to come to the US, I'm going to invest in this business so my spouse can get work authorization, but I don't really want to work in the business. So the develop and direct does not mean that you need to, work 40 hours. If you invest in a factory, you don't have to be on the line, cranking out widgets 40 hours a week, but you do need to be involved in the oversight and the direction of the business. So, checking in at a high level to make sure that everything is running properly. If you are not the investor, but you're an employee, so basically, if an individual or a company invests in an E2 company, one of the best aspects of the E2 visa is that company can then sponsor additional employees from the same country. So if it's an Argentine treaty company, the business can sponsor additional Argentines. Those people have to fill either executive or supervisory positions, or they have to have essential skills. So if you're familiar with the L1B visa, the essential skills worker would be something similar to the L1B. It's usually not quite as stringent a requirement, but those are the two ways in which you can employ E2 workers. And then the last one is that this is a non-immigrant visa. So again, historically over my career, this has not been a big deal in consular adjudications, but it, as of late, has become more important. And we have seen E2 cases that were denied on the basis of immigrant intent. So if the consulate thinks that you are coming on the US on an E2 to live here forever, they will not give you the visa. And usually a statement to the effect that you do not intend to immigrate, absence evidence to the contrary, is sufficient. So if you say, my home is in Argentina, I plan to go back to Argentina, I'm going to stay in the US for the duration of this visa, that's usually enough. But if there's other evidence, for example, you're married to a US citizen, that could be evidence that could be used against you in that regard. So let's touch base on a few other aspects of E2s. We've just gone through all of the regulatory requirements. E2 business plans are very specialized, and we will give you a recommendation for a business plan writer that we work with. When our clients do E2s, we almost always refer them to an E2 business plan writer. So a few things to know about the E2 business plan. Your business plan is going to be reviewed by either a consular officer, which is a State Department employee, or an immigration officer employed by USCIS. And these people are not bankers, investors, or accountants. They are more often people who have majored or studied or focused on areas such as criminal justice, homeland security, or international law. So important to know your audience. They only have about half an hour to review each case. They probably are not going to be interested in or even necessarily be able to process complex financial projections. You really need to keep it simple and tell a story and create a roadmap for them to see how your business meets the 9 requirements that we just went over. In the real world, a business plan is about 10% narrative and about 90% financials. In the E2 world, or the L1 world, the business plan is about 10% financials and about 90% narrative. So I think that's an important rule of thumb, is that the business plan looks really different in the E2 context. This is an individual, Marco Scanu. He has a business that focuses on creating business plans for visa cases. And so if you do proceed with an E2 visa case, we would definitely recommend working with Mr. Scanu or another business plan writer who focuses on the specifics of immigration business plans.
Wait, so
With
Becki,
regard
before you before you go business, go back to business life for a second. So I guess just recognizing the two different types of E2. So one is if you're buying an existing business, right? So if you're buying an existing business, you will have from your own due diligence of that business records of the business's operations that are going to go a long way to make the consular officer feel like, okay, this is a real business. It's been operating for the last 6 or 7 years. So they'll have tax records and employee records and payroll records and, all the good stuff that, one would expect with a good business. That said, you still want to have a business plan that says, consular officer, here's his business. I don't think they've been doing it well. I'm going to do it better. And here's who I am. Here's about me. And here's what I'm going to do with that business. Now, that's going to be probably a lot shorter business plan because it has the support of the existing business documents. Versus the other E2, which is a startup where you say, I want to go in the United States and I want to create a new business. I think there's a niche that exists and I'm going to start from scratch, right? So that's where the consular officer is going to say, okay, you don't have any operation in the United States. So I'm worried about whether or not this is just pie in the sky, or are you really going to do this? And so that's one of the tests that Becki talked about before. So the business plan will show why you're credible, why you think you're going to succeed, the research that you've done in the industry, and make that officer feel like you know what you're talking about, and I can't wait to come in to go visit this business because it sounds great. And the business plan sells it. And I agree 100% that you have to know your audience. And if you are going to like the business administration office to get a loan or a bank to get a loan, it would all be financial projections and numbers and very little narrative. But the consular officers, I agree 100% that it needs to be a great story, but that has the backup of the financial projections there to say, look, I know what's going on and I can show it to you, but here's the concept. And it's two entirely different products.
Absolutely. Thank you. All right, so to talk about consular considerations. So first of all, there are two ways to file an E2 case. One is consular processing, where you file your case at a U.S. embassy overseas. The other is a change of status in the United States. We really never do the second. I wouldn't say never, but almost never do the second one. And the reason is that these cases are really within the jurisdiction of the State Department. So even if you file a change of status in the United States, when you go overseas, you're going to have to do the entire case as if from scratch. So unlike other types of visas like an H-1B or an L-1, where you get a decision in the US and then the consulate basically rubber stamps it, in the context of the E2, they will look at the entire case all over again. So you don't get a lot by filing a change of status, unless, of course, you might have some need to stay in the United States. Maybe you have a medical issue, you can't travel. But otherwise, it's always best to file at the consulate, in my opinion. We're going to just briefly touch on inadmissibility and the status of consulates. So I will say that my partner, Sandra Grossman, who runs the individual immigration side of our practice, including complex consular inadmissibility, is always available to consult on issues if there are complexities. And I'm sorry, let me go back to this. So with regard to consular considerations, it's important to know that each consular post has its own requirements. We're working on a case right now in Serbia, and we learned that we have to have the physical filing couriered to the embassy. In other countries, like in Italy, you have to send it by email. It can't exceed a certain number of pages. It has to be in PDF format. So every consulate has its own rules, and you really need to find the rules for that consulate and make sure that you prepare for that. And then with regard to inadmissibility, so these are some of the questions that you will be asked on the visa application forms. They look at your social media. If you say, oh, I've been working in the US for the past year and now I'm going to get a visa, so it will be legal, you're probably not going to get an E2 visa. So be very careful about what you put on social media. A prior visa refusal, the diseases or health-related inadmissibility, prior convictions, and then Google tests. They will Google you, and if there is stuff online that will cause a problem with your visa application, they will find it. E2s are kind of weird with regard to their duration. So the visa validity varies by country. A lot of countries get a 5-year visa, but certain countries, like I think Australia maybe has a 2-year visa stamp. So really depending on the country, Mexico could have a 1-year or a 5-year visa stamp. So the visa, which is really just what allows you to travel, could be of a different duration. And the consulate, if they think, well, this looks like a good business, but we're not really sure we want to give the person full validity, they could limit it. But no matter whether your visa is good for 1 day or 5 years, every time you come into the US, you'll be admitted for 2 years. So you can stay for 2 years, but you get a visa validity according to the reciprocity. The last thing I want to say about consulates is that they are still backlogged from the pandemic. There were a lot of posts during the pandemic that just stopped processing E2s altogether. And usually these are priority cases. It actually says in the law that they're supposed to be prioritized, but we did see that some posts were not processing them. It's hard to get an expedited appointment, but they are available under certain circumstances. So, just be aware that the processing times may be longer than what was experienced in the past. The last topic on E2s that I'm going to touch on very briefly relates to taxation. And I'll just say that the E2 visa allows you to be in the US for as much time or as little time as you wish. So you can be here full time, 365 days a year. You could also use the E2 to direct and oversee your business and only come in maybe 3 or 4 times a year. And so if you are a high net worth individual and you want to not trigger a US tax obligation, you can do that under the E2 visa. So there's a substantial present test, which basically tabulates the number of days that you've been in the US the current year, the prior year, and then 2 years ago. And if the sum of those visits to the US exceeds 182 days, then you are likely subject to US taxes. If you're a permanent resident, you're taxed on your worldwide income. If you're a non-resident, you're taxed only on US source income. So these are rules, and I'm just, as I said, I'm not a tax expert. I'm just really summarizing them briefly for you. There are tax treaties that could apply that may impact your tax liability. Len Wolf is a CPA in town that we work with frequently, and we refer our clients who have tax questions to him. So if you do have questions about E2 taxation, we'd recommend that you reach out to Len and his firm. And with that, I'm going to turn it over to David, who's going to talk about the EB5. And we have a few examples of how the EB5 interacts with the E2. But for now, let me ask David to give you the basic parameters of the EB5 category.
Great. Thank you, Becki. So unlike the E2 investor visa, which is a temporary visa, the EB5 investor visa program is a green card. So that is permanent residence. That means you can live here, work here, do everything almost like a U.S. citizen. So the EB5 program gives permanent resident card to an investor, spouse, and all unmarried children, unmarried under age 21, and here's the basic qualifications. If you make a minimum capital investment, right now it got moved from $500,000 to $800,000 about 2 years ago when the law changed. So a minimum capital investment of $800,000, and that's in special areas, or it's $1,050,000 anywhere else in the United States. And you have to make that investment into a new U.S. company or business. You have to demonstrate that the investor's funds were lawfully sourced. That means you obtain those funds by legal means, and we're going to have to do tracing and sourcing of those funds to prove that your funds came from legal sources. Could be from property sales, from inheritance, could be from salary and income from a business, but we have to prove that out. we also have to create that your investment into the new company will create 10 full-time jobs for US workers. So where Becki mentioned before on the E2 program, you should create some benefits for your US workers. Here they say it must be 10 full-time jobs, right? It's just like the E2 investment amount is unstated, it's be substantial. Here they're saying it's a minimum of $1,050,000 or as low as $800,000. And the investor must engage in some management role of the new company. However, you can be active or you could be a limited partner or a passive investor, which is a limited partner is pretty much the opposite of the of an active investor, but the regulations allow a limited partner. Many partnerships are set up where the general partner manages the business, but has to consult with the limited partners, the passive investors, only on some major decisions, and that may be 1 or 2 a year at most. That allows the limited partner EB5 investor to live wherever they want in the United States. They don't have to live in the same city as the business. So that's basically how the EB5 program works. Now there's 2 different EB5 programs. There is the Regional Center program, which represents about 95% of all EB5 green cards. That is where a person will join an existing business, generally as a limited partner. They are passive and they let the business run the business, manage the capital, responsible for all the job creation. That entity is licensed by the Immigration Service to do these types of projects. That represents 95% of the business of EB5 investors. And then the other 5% represents entrepreneurs who are making an investment into their own business that they're going to run, more akin to the E2 visa program. And again, that only represents 5% of all EB5 investors. So that's the basic overview of the EB5 program. Next slide.
Okay.
All right. So let's do a quick compare and contrast, because I think there's some important differences between the two and some similarities. So we're using this, let's suppose an Italian restaurant entrepreneur wants to open a new restaurant in DC. So the E2 visa that Becki talked about, there you would apply for the visa at the US Embassy in Rome. Whereas the EB5, we would file a petition here domestically with the US Immigration Service, and we would seek qualifications through the immigration agency. Whereas E2, Immigration Service has nothing to do with it. You're asking the US consular officer at the embassy to make the decision. Processing time is a big difference between the two. So for the E2 visa, from the time you put together your application package and we email it to the consular officer at the embassy in Rome, it might take them a couple months to look at it. And if they have questions, they'll send questions back to us requesting for more information. But more or less, it's a relatively quick process, relatively quick. However, the EB5 investor visa program right now, when you file your application with the Immigration Service, it's taking them 55 months. Yes, 55 months for them to get your case and to look at it and to make a review. So obviously that is dramatic difference. That is a big reason why a lot of people are not interested in EB5 these days. It used to be that it was 12, maybe 20, 24 months of processing time. But through COVID and even before, the processing times continue to push up. So that is a big impediment to a lot of people's interest in that. Unless you can be in the United States, and if you file with the Immigration Service, you may be able to stay here on your non-immigrant visa or in another status while your case is pending. So that is a workaround to waiting outside for 55 months outside the country to come in. So in your E2 visa, if it gets approved, the consular says, congratulations, you've got your visa. They put the stamp in your visa and your passport. You enter the United States and you start running the business from day one. If the U.S. Immigration Service approves your case, that's step one. Then they send your file to a middle agency called National Visa Center, who then sends it to the U.S. Embassy for an immigrant visa interview. that might add another year of extra processing from the time the Immigration Service approves your case to the time you're called in to the interview at the embassy to get your green card. So again, it's a long, slow process. The E2 visa, the spouse is allowed to get a work card, a visa and a work card, as well as children can come in. So again, fast turnaround times, immediate benefits to family members. The EB5, when the investor gets the green card, again, spouse and all unmarried children, they get green cards at the same time. However, the green cards that everyone gets under the EB5 program are 2-year green cards. That means you will be a permanent resident for 24 months. And at the end of that 24 months, we'll have to file another petition with the Immigration Service that is kind of a look back, right? It says, "Dear Immigration, we said that we were going to invest $1 million or $800,000 into this business. We're going to create these jobs, and that's how we're going to satisfy our requirement." So the Immigration Service is requiring at the end of this 2 years, show us that you've done all that stuff. So this is where the business plan is really important. Show us that you satisfied your business plan. And at that point, we'll have to show them that we made the investment, that we sustained that full amount of investment, and that we've created the jobs, or we're at the very end of creating those jobs. And only if we demonstrate the satisfaction of all those things will the Immigration Service issue another green card of a limited duration. If you don't prove those things, then they will move to cancel that green card, or they will not extend it, in which case you will theoretically lose all your immigration benefits. So it's a very different process. Compare that with the E2. So if you get your 5-year visa, generally, if you're continuing to run your E2 business, you have employees, it's operational, more or less, the embassies will continue to extend that green card, extend that E2 visa as long as you're continuing to run it. So those are kind of two big differences between these two investor visa programs.
Thank you, David.
Mm-hmm.
And I would be curious to know, I mentioned earlier that the BRICS are not included in the E2 program. I'm curious to know, since those are big countries, probably with a lot of interested investors, what percentage of EB5 clients that you've seen come from those countries? Because I think the E2 has a lot of advantages. So I'm wondering if the EB5 is largely taken up by people who are not eligible for the E2.
Well, yeah, that's a really good question. So when the processing times were a lot faster, when they were 12 to 24 months, people didn't mind waiting overseas to get their EB5 green card and coming in. When that started to creep up, people had to become really patient and adjust their expectations of how long it was going to take for them to get their green card and come. So people would then employ strategies of like, well, maybe I don't want to wait that long. So maybe they would come to the United States as an F1 student and apply, and they would stay here as in student status. And then under the new laws, the person, if they applied for EB5 as a student, could then domestically get benefits to allow them to stay here and work here on the EB5 while it's pending. Other people would come in on their other non-immigrant visas. But in general, I think most people, certainly all the Chinese, would wait patiently overseas because they did not have the E2 visa option. Same thing with India.
Yeah.
So going back to our example of an Italian restaurant entrepreneur seeking to open a new DC restaurant. So the E2, we talked about there's no minimum capital investment, but we're talking, $150,000 to $200,000 of initial investment. That's what we think you should have. So if you're a new restaurateur, can you start a new restaurant in DC for $200,000? Might be hard, right? That's not a lot between equipment, lease up, expenses. So you may need to invest more, not because the E2 visa requires more, but just you need to put in more just to make your business operational. Compare that to the EB5 that says must be $800,000 if you are in a targeted employment area, a rural or high employment area, that's where your business is located. Otherwise, you have to demonstrate that you put in at least $1,050,000. Like, we have to include that evidence in the package. E2 business, you can use your investment capital to buy an existing business. And I think in some ways that could be an easier way to start your new entrepreneur venture in the United States versus creating a new business from scratch. I mean, it's like buying a used car, right? So there's some advantages. It works right today, but there's a reason probably why someone's selling it. It needs new brakes and a muffler and tires. So if you're buying existing business, you really have to be wary. What are you getting into, and what don't you know? And is there any kind of major problems that you're going to face? So it might be easier to get the visa in an existing business scenario, but maybe you're going to have more problems down the road inheriting them. For EB5, starting a new business is really the way to go. You can expand an existing business, but it's actually much harder under the EB5 rules. So for the most part, it's new business structures is the way EB5s will work. E2, no minimum job creation. So maybe you're going to buy a business that has 4 or 5 employees. That might be just fine for E2 visa. For EB5, you must create 10 new full-time jobs. So those are W-2 employees. That's not the regional center version, which allows you to do indirect job creation by economic modeling. But if you're a direct EB5 investor or entrepreneur, you have to create 10 full-time jobs. And so that's a hard thing to do. Again, E2, as Becki mentioned before, the investor needs to be kind of more active in the operation. Where, as I mentioned, EB5, you can be a purely passive investor. You could be a limited partner where your role is really limited to very few activities, allowing you to live anywhere in the United States. So those are the kind of two visa examples if we were using a restaurant as the hypo.
Okay. And then I think we have a quiz here if I can advance these slides. So these are just some questions about EB5 versus E2.
Yeah, so let's jump into it and see if everyone's been paying attention. So an Italian citizen seeks to passively invest $1 million to help an Italian friend chef open a new DC restaurant. So EB5 or an E2? I don't know, Becki, what do you think?
Well, that word passively definitely tells me that it can't be an E2. I might talk to this client to see how passive they want to be about it. But as I mentioned, the E2 investment has to be active. It can't be passive. So if this person really wants to passively invest, I would say they can do that, but they're not going to get an E2 visa from a passive investment.
Yeah, I think right. If I think we would have to talk to the investor and say maybe you need to bump up a little bit more from passive, and then you could qualify for an E2, right? And if you did, because you would have an Italian citizenship, then your Italian chef who has the same citizenship as the investor might be able to come in if he or she needs a visa to come in on as an E2 employee. So maybe that's an option. The invest $1 million. Well, so for EB5 purposes, if the if the restaurant in DC is located in a target employment area, which is a high unemployment area in DC, then $1 million would work because the minimum investment requirement is $800,000. But if it was in Georgetown or some other nice place in DC, then $1 million is actually not enough. They need $1,050,000. So,
although David, didn't you tell me that Hudson Yards in New York in Manhattan was identified as a TEA?
It was, but when they changed the rules 2 years ago, they stopped the ability for gerrymandering of census tracts in order to create a high unemployment area. So, but yes, in the days past, yes, now they're trying to stop that. So let's go to number 2. A Swiss citizen seeks to actively invest $1 million to help an Italian chef open a new DC restaurant. So on this one, it's hard to think about an E because, there's a treaty between the US and Switzerland, I suppose, right? Isn't that, Becki?
There is, and I would actually say so. There is a nationality issue here, but the Swiss national only needs to own 50% of the treaty enterprise. So if the restaurant was owned 50% by the Swiss investor and 50% by the Italian chef, or really anyone else, that could work. So it doesn't have to be a majority share. 50% ownership would be sufficient under the theory of negative control. But yeah, that's the only way it would work, is if the Swiss national owns at least 50% and it becomes a Swiss treaty restaurant, not an Italian treaty restaurant.
Right, right. So maybe E2 works. The $1 million is a good amount, right? That's going to pass the substantial test. Likely, if it's a DC restaurant, you're going to have enough employees to have more than marginality. So yeah, that might work for E2 purposes for the Swiss national. It wouldn't help if the Italian wants to be the driver of it all. That wouldn't help because well, the Swiss could make the investment, right? But if they were 50% and the Italian chef was the other 50%, then perhaps then they could be an Italian citizenship of the restaurant. So for EB5, again, that might work for the Swiss citizen, except we don't know if maybe the 1 million would work where the location of the restaurant is going to be. So maybe if it's a high employment area, yes. If it's not, then they're a little shy of that. So let's try number 3. Italian chef to personally invest $200,000, and then she's gonna have family and friends loan her $800,000 for a total investment of $1 million to open up a new DC restaurant. So let me talk about it from the EB5 perspective. So the Italian chef would say, look, I'm investing $1 million, and if you need to, I'll throw an extra $50,000. So I'm going to make $1,050,000 to open up a new restaurant in Washington, D.C. Shouldn't I qualify for an EB5? And the answer is no. So yes, you're investing $1,050,000, which is the minimum requirement. However, the Italian chef is only personally investing $200,000. The rest is coming from a loan. And the Immigration Service would say, we only care about how much you are personally investing. And so while you're putting in $1,050,000, you're only putting in $200,000, does not qualify for EB5 purposes. What about for E2?
Yeah, so interestingly, in the E2 context, I would say this fact pattern is totally fine. So you can definitely use your personal funds. You can also use a loan as long as it's not secured by the assets of the business, but it could even be an unsecured loan. And interestingly, a family and friends loan could actually, the funds could even come from a US source. So if you have an American, girlfriend, boyfriend who wants to give you the $800,000 gift or loan the money to you, that would be okay for the E2.
Yeah, that's a good E2 case right there. All right, last one. Italian chef to personally invest $100,000 to buy and renovate an existing DC restaurant. So let's talk about EB5. So would not qualify at all because it's far below the minimum investment amount of $800,000 or $1,050,000. But even if we added enough extra capital in for the chef to personally invest, buying and renovating existing restaurant, existing business is hard under EB5 because you have to create more than 10 jobs. You have to create 150% of the jobs that existed before, unless we can prove that the business is going to go under. It's a failing business, and there's a test that we use for that. In which case, the chef would only need to sustain those 10 jobs, right? But we'd have to show substantial losses of 150% over the last 2 years. So no EB5 because of the minimum investment amount. But if they bumped it up, then maybe they could do it under some exceptions. What about E2?
So I do think there's a substantiality issue here. So $100,000 is not, a huge amount of money in the E2 context, but this is a case that I would take a closer look at. Because it is an existing restaurant, if there's an independent analysis that says $100,000 would be sufficient to buy the whole restaurant and renovate it, and you can show that the restaurant has a track record, that it has employees, I think this is a case that consulates, could approve, assuming that it really that it passes the laugh test of whether $100,000 is sufficient to purchase the entire business.
I agree 100%. Yep. All right, well, so there's our quiz.
All right, awesome. So I am going to try to end the slideshow here and come back to Zoom. Let's see here. And I will ask Christina to end the recording, and then we'll stick around for a little while to answer any questions if there are any.